Lorenza Davis was a Bible study instructor appointed by a Jehovah's Witnesses congregation in Cordelia, Georgia. Between August 2019 and February 2022, he entered a child's home over 100 times and harmed that child. He confessed to investigators. In March 2024, he pleaded guilty. The judge sentenced him to 60 years in prison. That is the criminal case. It is closed. But on February 13, 2026, a federal lawsuit was filed in the U.S. District Court for the Middle District of Georgia. And this time, the defendant is not just Davis. The lawsuit names the governing body of Jehovah's Witnesses directly, the top of the entire global organization. And the law firm behind it has recovered over $1 billion in institutional negligence cases. The question this case is now forcing a federal court to answer is not whether Davis is guilty. He already admitted he is. The question is whether the institution that appointed him, that sent him into that home week after week, that supervised his access to that child, bears legal responsibility for what happened inside those walls. And the answer to that question could have consequences for religious organizations around the world. Part 2. Lorenza Davis Jr. was 28 years old when investigators caught up with him in February 2022. He lived in Cordelia, Georgia, a small city in Crisp County, about 2 hours south of Atlanta. And his connection to the family he victimized was not accidental. It was structural. It was institutional. Davis held a formally appointed position as a Bible study instructor within a local Jehovah's Witnesses congregation. But here's a detail that makes this story even more troubling. According to Fox 5 Atlanta, Davis was not only connected to this child through the church. He was also a former employee of the Crisp County school system. Investigators confirmed the school connection at the time of his arrest, but did not specify what role he held there. What that means is this. Davis had pursued institutional access to children through two separate systems at the same time. A public school and a religious organization. Two institutions. Two sets of adults in positions of authority who were responsible for vetting who had access to the children in their care. That context matters enormously for the civil lawsuit. Because one of the central arguments the plaintiffs are making is that the congregation failed to properly screen and supervise Davis before placing him in a role that gave him repeated, unsupervised access to a minor. When you add the fact that he had also worked inside the public school system, another institution built on trusted adult access to children, the question of due diligence becomes even sharper. What did the congregation know about who this man was before they sent him into that home? The role of Bible study instructor sounds modest on the surface. But inside the Jehovah's Witnesses organization, Bible study is central to everything. It is how the faith is transmitted, how new members are brought in, how existing members are guided. Instructors are given access to families' homes. They sit at kitchen tables. They pray with children. They are, by definition, trusted figures. And that trust is not incidental. It is granted by the organization. It is the organization that appoints them, the organization that sends them, and the organization that is responsible for who they are. Davis began his sessions with this particular family in August 2019. What happened inside that home over the months and years that followed would not come to light until law enforcement got involved in early 2022. According to the investigation, the harm inflicted on the child in this case was not a single incident. It was a pattern. A repeated, sustained pattern of predatory behavior that the victim experienced more than 100 times. 100 separate incidents of harm committed against a minor by a man the church had placed in his life. When investigators confronted Davis, he did not attempt to deny it. He confessed. He told investigators what he had done. And in March of 2024, standing before a judge in Georgia, he entered a guilty plea to 2 counts of aggravated crimes against a minor. The sentence that followed was 60 years in prison, with the first 27 to be served without the possibility of parole. Lorenza Davis will spend the most productive decades of his life behind bars. He is not going anywhere. But here is the question that a criminal conviction cannot answer. Here is what no prison sentence, however long, actually resolves. How did this happen? How did a man with access to a child inside a structured, organized, institutionally supervised religious program manage to victimize that child more than 100 times over the course of 2.5 years, without anyone inside that institution stepping in to stop it? That question demands an answer. And the attorneys who filed the February 2026 federal lawsuit believe they have found it. Part 3. On February 13, 2026, a civil complaint was filed in the United States District Court for the Middle District of Georgia. The legal team behind the case is Romanucci and Blandon, a Chicago-based firm that has built its reputation on holding powerful institutions accountable for systemic failures. They are working alongside the Georgia law team. Together, they represent the victim in this case, and they are not targeting just the man who confessed. They are targeting the organization that put him in position to cause this harm in the first place. The defendants named in this federal lawsuit include the governing body of Jehovah's Witnesses and multiple legal entities tied to the Watchtower organization, corporations registered in New York, Pennsylvania, and Florida. To understand why that matters, you have to understand what the governing body actually is. The governing body is not a local committee. It is not a regional office. It is the supreme leadership of the entire Jehovah's Witnesses organization on a global scale. They set the theological doctrine that every congregation follows. They produce the publications that guide the behavior of members worldwide. They establish the internal policies that dictate how congregations are run, how members are appointed to roles, and how situations involving misconduct are to be handled. Every congregation elder in every country operates under their authority. Every policy that governed what happened, or did not happen, in that cordial congregation traces back to them. This is why naming the governing body directly in a federal lawsuit is so significant. Civil cases involving religious institutions often stop at the local level. One congregation, one group of elders, one regional entity. Going to the top is a deliberate legal strategy. It is a statement that the failure in this case was not the result of one rogue congregation acting outside the organization's norms. The failure, the plaintiffs argue, is the result of the organization's norms themselves. The three legal claims at the center of this lawsuit are negligence, failure to supervise, and failure to train. Each of these deserves a moment of explanation because together they form a powerful argument about institutional responsibility. Negligence means the organization had a duty, a legal and moral obligation, to protect the children participating in its programs, and it failed to fulfill that duty. Failure to supervise means that the congregation elders, who were aware that Davis was conducting one-on-one Bible study sessions alone with this child, allowed that arrangement to continue without adequate oversight. And failure to train means that the organization did not equip its leaders with the protocols, the awareness, or the accountability structures necessary to identify and prevent the kind of harm that was occurring inside that home. The lawsuit places particular emphasis on one fact that is difficult to set aside. During the COVID-19 pandemic, a period when governments around the world were restricting close personal contact, when schools were closed, when churches were holding services online, Davis continued his private, unsupervised, in-home sessions with this child. If there was ever a moment when an institution should have paused and reconsidered who had access to its most vulnerable members, it was then. According to the lawsuit, that pause never came. And then there is the allegation that strikes at something deeper than policy failure. The plaintiffs allege that when this organization faced a choice between protecting this child and protecting its own reputation, it chose its reputation. That is a serious allegation. If it is proven, it does not simply establish negligence. It establishes a deliberate prioritization of institutional image over a child's safety. And that changes the entire moral character of the case. Part 4. To understand the full weight of what this lawsuit represents, it helps to step back and look at the broader context in which it is being filed. The Jehovah's Witnesses organization has faced scrutiny over its internal handling of misconduct allegations in multiple countries over many years. Government commissions in Australia and the United Kingdom have examined the organization's internal policies and raised serious concerns about their adequacy. In the United States, investigative journalists and advocacy organizations have documented dozens of cases where victims allege that congregation elders did not report misconduct to civil authorities, handling matters internally instead. One particular internal policy has been at the center of much of this criticism. Historically, the organization has applied what is known as the two-witness rule to serious misconduct allegations, a principle drawn from biblical text that requires more than one witness to confirm an accusation before formal congregational action is taken. Critics of this policy, including child protection advocates, legal experts, and former members, have argued that in the context of crimes committed in private against children, this standard is not only inadequate, but actively harmful. A child victimized in their own home is almost never going to have a second witness. And the absence of a second witness, under this framework, could mean the absence of any institutional response. The Watchtower organization has defended its policies in public statements, arguing that it complies with applicable laws and that the safety of children is a priority. But the accumulation of cases across multiple countries, and now this federal lawsuit reaching directly to the governing body, suggests that a growing number of legal professionals and survivors believe the gap between that stated priority and the institutional reality is significant and provable in court. What makes Romanucci and Blandin's involvement in this case particularly notable is their track record. This is not a firm that files speculative lawsuits hoping for a settlement. They have a documented history of winning substantial verdicts and settlements in cases involving institutional negligence, cases against schools, healthcare systems, corporations, and government entities. When a firm of that caliber chooses to name the governing body of a global religious organization in a federal lawsuit, it is because they believe the evidence supports it and that they can prove it in front of a jury. Part 5. Let's talk about what accountability actually looks like and why civil cases like this one matter even when the criminal case is already resolved. A criminal conviction punishes an individual for a specific set of acts. It answers the question of what that person did and what they deserve as a consequence. But it does not interrogate the institution. It does not require a church, a school, a corporation, or any other organized body to explain how their internal structure enabled the harm or what they are going to do to ensure it never happens again. A civil lawsuit against an institution does exactly that. It forces the organization into a courtroom where its own documents, its own policies, its own internal communications, and its own decision-making processes become subject to legal scrutiny. Discovery, the process by which both sides in a civil case exchange evidence, can compel an institution to hand over years of internal records that were never intended to be made public. And what those records sometimes reveal is that the institution knew more than it claimed, acted less than it should have, and protected itself at someone else's expense. This is the mechanism that has brought accountability to powerful institutions in the past. It is how the full scope of the Catholic Church's internal mishandling of misconduct claims was exposed in city after city, country after country. It is how major universities and athletic programs have been forced to confront patterns of harm that administrators were aware of and chose not to address. The civil process is slow, it is adversarial, it is expensive. But it has a power that criminal prosecution does not. It can reach the institution itself and hold the structure accountable for the harm the structure produced. In this case, the institution is global. The governing body of Jehovah's Witnesses oversees millions of members on every continent. A finding of institutional liability in a U.S. federal court would not simply affect one family in Georgia. It would create a legal precedent with implications that extend far beyond this case, affecting how the organization trains those who work with children, how it supervises access to minors in its programs, and how it responds when something goes wrong inside a congregation anywhere in the world. This case is still in its early stages. No verdict has been reached. The governing body has not been found liable. The legal process will take time, and the organization will have the opportunity to present its defense. Those are the facts of where things stand. But here is what is not in question. A child was harmed. The man responsible confessed and is serving 60 years in prison. The harm occurred over 2.5 years, more than 100 times, inside a program that a religious institution organized, sanctioned, and was responsible for supervising. And a federal lawsuit has now been filed that asks the most powerful leadership of that institution to stand before a court and explain what they knew, what they did, and whether they did enough. Because the truth of this case is not complicated. When an institution places a person in a position of trust and access over a child, that institution accepts a responsibility, not a suggestion, not a guideline, a responsibility. And if that institution fails to honor that responsibility, if it looks away, if it prioritizes its own image, if it allows harm to continue because confronting it is inconvenient, then the law exists precisely to hold that institution to account. 60 years in prison for Lorenza Davis is justice for the crime. But justice for this family, and for every family that places its trust in an institution that claims to stand for something higher, means asking the harder question and getting a real answer. The federal case is active. The governing body is named. We will be watching every development and bringing it to you as this case moves forward. If this kind of in-depth coverage matters to you, subscribe and share this video. The truth needs people who are willing to pay attention.